The review is coming. One can see it coming because there's a lot of public clamor and a public appreciation that these companies have a huge amount of power and they're not being reined in by the law as it exists, as it is applied today. I think one thing that could happen is Congress decides, break up Facebook and the others, and it breaks them up, and then consumers don't see any benefit in the end. So maybe there should be regulation. I mean, antitrust is one piece of it. It's not the whole piece of it. There are privacy problems, there are deception problems, there are consumer protection problems. The companies should be more tightly regulated not to do various things that they're doing with their data, for example.
They don't pedicure before
roughly cut my fingernails.
There ought to be a rule, and the Federal Trade Commission is well placed to articulate and publicize such a rule. There ought to be a rule that if you're a dominant platform, you have to, and you're also hosting yourself on your platform, you have to apply neutral principles, that you should not be able to give yourself all sorts of privileges and demote your rivals, let alone sabotage them. It ought to be a rule, and it ought to be a clear rule. And it's too bad, though, today, given our system, we probably have to go through years of litigation to decide whether the conduct was illegal, and if it's illegal, what to do about it. And then after many years, we might possibly come to a principle of law like that. So the FTC could promulgate that rule. After hearing, after getting a lot of evidence, after determining that it was really the right and better thing to do. Monopoly is usually defined much more technically in the law than it is in common rhetoric. And it usually means ability to raise price significantly for a significant period of time. And these companies aren't about price raising. They have a sometimes zero price for consumers. And therefore, the paradigm that we use for testing whether a firm is a monopoly firm doesn't work well. We need to be more flexible. And I think under our Sherman Act, it goes into the courts aren't going to be very flexible. Secondly, that's only as to whether they can prove there's monopoly power. Secondly, whether they can prove that there was an abuse of monopoly power. And our Supreme Court has basically said when somebody invents something, they ought to be, so as Google invents the platform, Facebook invents the platform, they ought to be able to use it. They ought to be able to say, well, I made it, I could do what I want. And the idea behind that is the thought that if you let them do what they want, there will be more innovation. That's a contested proposition, but it is a point of view that is accepted by a great number of people, and probably a majority of our Supreme Court. So that's why we have what we call laissez-faire antitrust. The antitrust law, especially for monopoly firms, is very much a toothless tiger. And the Federal Trade Commission has this more flexibility under the Federal Trade Commission Act, and it doesn't have to use it. It might decide that it agrees with the conservative Sherman Act approach, but it could decide that it doesn't agree. And it wants to apply the law. It could decide it is seeing anti-competitive activity, and it wants to apply the law against it. So Facebook acquired Instagram and WhatsApp at a time when these companies were really small. And Google also made acquisitions when the companies were really, really small, only had a few people. It's very hard to predict whether those acquisitions would be pro-competitive or anti-competitive. So there is the side of argument in favor of no violation, that acquiring the companies only made that line of business more interesting, more options for consumers, also keeping open the channels of mergers actually can induce more companies to want to be startups because they compete to be bought.